Now, I haven't taken my 5 minutes of questioning yet, but I'm going to go ahead and do it. I'm going to limit it to, I think, 3 questions. And
I have the gavel.
you shook the gavel from me? Yeah, she's good. She's going to pop me with that gavel. Okay, we're going to start with you, Mr. Turley, please. Let's get with this. Capacity of state and district courts to keep records and information sealed. That's one of the critiques we have about moving away from a FISA court because, oh boy, there'll be leaks as if there's been no leaks in the current scheme. So tell me your experience there, and is it possible for state and federal courts to keep information sealed?
Yeah, I always hear this objection, and it has no support at all. I deal with national security cases through regular Article III courts. Throughout the years, they have SCIFs, they have training, they're cleared. There aren't these allegations of leaks. The issue with the secret court is that no one's objecting that you can have a secret court in the sense of a giant SCIF where secret proceedings can occur. You can even have judges that are selected and trained for that purpose. The question is whether the standard for U.S. citizens and U.S. persons should be different in that courtroom. And I have never accepted that to be the case. I don't see an exception under the Fourth Amendment.
Right. I appreciate that, and I'm in agreement with that. And Mr. Chair, I'm going to go to you next. The gentleman from Georgia kind of intimated that somehow data collection and querying is similar to an officer in a patrol car driving around and observing suspicious activity, maybe making a Terry stop, or whatever you want to call it. But how is this different, and why should we equate this more like to a wiretap rather than a stop and frisk?
I think it is very much more like a wiretap. I mean, yes, if you're a police officer, you have a right to be on a highway and watch what goes by, but that doesn't mean that you also get to have a helicopter flying over the neighborhood and taking pictures of everything that happens in every home in that neighborhood. And so, by all means, I think the wiretap analogy is the right one to use, because that exactly is what 702 is doing. Is it's taking a stream of data, a massive stream of data, and just pulling things out of it, and even if it's appropriate to collect the data, there need to be Fourth Amendment protections when it comes to searching that data, especially
just as you would have in a wiretap. I mean, when you narrow the search down, you've made it particularized. You've targeted somebody.
Right.
You're going forward and getting a warrant, right?
Right, and searching a database with somebody's name or other identifying information is more analogous to a wiretap.
And so I want to get to this other thing too, Ms. Goithin, and that is dealing with purchased information. And I think Professor Turley kind of got to it a little bit, is that they wrap it up. And when we've been briefed by the FBI on this, they talk about multiple databases that they're using, and then there's a wall that's created. Why should we prohibit the use of purchased material when we know other nations are using it?
Well, that's an important question. And let's be clear that we are talking about material that the government would need a warrant or a court order or a subpoena if it were compelling the production. So we're talking about sensitive information about U.S. persons. The reason the government can buy this from data brokers is because there are loopholes in the law. The law does prohibit phone companies and internet companies from selling this type of data to the government. But that law is from 1986, and so it doesn't address digital data brokers. They didn't exist back then. So there's this loophole where the companies cannot sell it to the government. They can sell it to data brokers. The data brokers turn around and sell the same information to the government at a handsome profit. So the information is laundered through a middleman. Now, we should be concerned about the fact that foreign governments can get this information. Congress absolutely should act on that problem, and the Brennan Center is in favor of comprehensive consumer data privacy legislation. That should not stop Congress from acting now to make sure that our government can't exploit this loophole, because when the U.S. government is obtaining American sensitive information, there are risks and harms to American civil liberties that go beyond what can happen when private entities can get that information, or even foreign governments, because the United States government has coercive powers over American citizens that private companies and foreign governments do not have. The ability to put us in jail, the ability to deport people, to tax you, to fine you, to put you on a no-fly list, to withhold public benefits. There are all kinds of ways in which the government can impact our liberties. And for that reason, the Fourth Amendment applies to the U.S. government, not to private actors, not to other governments, and Congress should make sure that the U.S. government is honoring those Fourth Amendment protections.
Well, my time has expired, and I thank each one of you. You've provided us with some information, and I think is vital, a lot of comments. And what I would ask of you is, as we go forward, we may have ideas, legislation that we want you to review. Please make yourself available. We appreciate you making yourself available.
Mr. Chairman.
Yes, and I believe there's some unanimous consents.
Yes, Your Honor.